All right, it being the top of the hour, I'm going to call this meeting of the Zoning Board of Appeals to order. First administrative item, we've got a set of minutes from January 5th. I believe Andy has already provided some edits, but otherwise, the red line version is what's before you right now. Otherwise, it's a pretty short minute, so I'll give everybody a minute in case they want to propose any other changes.
Make a motion that we accept the meeting minutes as edited.
Second. We have a motion, we have a second. Any discussion? Hearing none, all in favor of accepting the minutes as amended? Okay. And the minutes are accepted as amended. I believe the only piece of correspondence that we've received so far pertains to the appeal that we're going to hear at 7:15. So I'm not going to identify them right now. Any updates of zoning or planning nature? Anyone want to mention? We've got a couple of minutes. I know that. Is it Rick raised the issue about whether or not you want to? Did you want to? Was it a rule that you wanted to put in, or just guidance about applicants having to appear versus Zoom?
I just found it very difficult and annoying when we had that one hearing on Gleasondale that the guy wasn't here to explain what his house layout was, and it causes problems.
Mhm.
Slowed us down. We didn't, and we're not sure why. Even that was the best place to put the stairs because a variance was involved.
Right.
So that was kind of annoying. And it just seems to me that as a general rule, they should be required to be here. Now, like this one here, if someone's down in Florida and lives there, and then I have no problem with using the internet to communicate. It's just it's awkward at that time, and we've had a few times in the past. That's just not the ideal situation for us to make the findings and the decision we make.
Other thoughts?
No, I think I would agree with that. I think short of any hardship issues or distance issues, I think it's appropriate for the applicant to be present. I know we got technology that can, but the technology should be more the exception rather than the rule for the applicant.
Like during COVID, it was fine. Everybody was concerned about it, and there was no other way to conduct the meeting, and it worked, not ideally, because displaying things is difficult over the internet. But,
is there a thought that maybe it's sort of the applicant sort of takes the risk by not showing up and therefore not properly communicating, what the message should be, and or like they take the risk that they didn't present their case as well as they could have if they had been in person?
But it also puts us in a bind if we don't get the information we really need to make a decision. Whereas it looks like it might be okay, but it's not there to really provide the information we need.
I think the implication there is if we ever felt like we didn't get the information, arguably it's probably going to get turned down versus.
Right. Or at the very least, we can say, we don't understand what you're talking about. Come back next time. And,
okay.
Or but I'm not pushing back. I'm just, it's like, maybe it's because I was at the last meeting, I couldn't make it. So I took advantage of the fact that we could do this online. I mean, don't get me wrong. I agree. I think it's a lot easier when the person is actually physically here. I think it's clearer. It's easier to ask questions. Plus, there's always the risk that, thankfully, technology is actually working well for our last number of meetings. But I definitely remember times before where we were sitting here for 30 minutes or more because things weren't working correctly. We could. One idea is that I have to go back to the sort of the disclaimer that we have in the notice, whether or not we want, like, whether it's worth even like putting some guidance either on the website or something like that, it essentially says like, the risk is on you if if we don't understand you. I don't know, that's,
Somehow
That's always true. That's always true.
yeah,
I mean, I think that the issue would be, if there's some kind of documents that we wanted and we couldn't get them.
yeah,
Otherwise, I don't know, I mean, even courts now are doing Zoom and they're like the last ones to embrace any kind of technology change.
Yeah, I think what you described, Lenny, was one of the circumstances that we dealt with that night. Andy was trying to find stuff and, get it here and show it there and whatnot. So it was cumbersome
Yeah,
for sure.
yeah, with information, if you need documents, it's true, yeah.
And the fact is, we show up for the meetings.
Well,
Most of the time.
I had an issue. I don't
No
know.
attendance reports tonight.
Yeah. But I mean, honestly, like, yes, we could participate with Zoom, but like, it's easier for me as a member to be here in person and to talk to the, to the applicant or to the members of the public, or even just for us to converse. I mean, otherwise you have to sort of like virtually raise your hand.
It's even awkward when someone comes in and wants to say something in our meeting, they can't really point to things, they can't really do things that, it'd be nice if they did.
Yeah.
So,
I mean,
we can put up with that, but it's a
Yeah.
comment.
I mean, theoretically, could we, like, I'm just wondering too, it's like, can we actually require it? I mean, when we offer when we're offering the web conference,
I know a lot of the state law says it. I'm
Yeah.
not sure the wording of it, so.
I don't know if you have those thoughts.
The advice that I've been given is if we want to require people to be in person, we would have to change it to be an in-person only meeting. Or if we don't want to have a requirement, we keep it as is. So,
We can certainly encourage it.
yes. We can certainly encourage it when we talk to the applicants, but I don't know if there's any other changes that we can do to increase
Other than just eliminating the Zoom entirely.
without eliminating Zoom.
And that has the unintended consequence that if you're a member of the public and you want to either listen in or participate, we can't make it,
Because we found that Zoom is having a hybrid is more inclusionary of everyone.
It
So
is, no question about that.
keeping the option open can be beneficial.
I mean, I think to the extent that you don't already, I mean, I think definitely encouraging people to make sure that they do come up, understanding that, it's essentially it's on them if there's a misunderstanding or miscommunication because they're not here. So, and I guess the other piece would be like, if they don't show up, it would be nice if there's a reason, if they say, hey, I can't make it because I've got the flu and I don't want to infect everybody, or I'm out of state, or I have a family emergency, as opposed to, I don't know, it's cold tonight, I'd rather just not show up,
It's more for me to stay at home, that's for sure.
Yeah. So, okay.
Okay.
Any other administrative matters at the moment? Okay, all right, public hearing starts at 7:15, so we'll sit tight till then.
They're all here.
Are you traveling? What's that? Bringing calls, yeah, no, that's great. That's good. That's good. Good, good. It's, yeah. Yeah. So, yeah, it's good. They don't want me there, but. Yeah, it's nice.
All right, it being 7:15. We have, 1 second. I will move on to the public hearing, which is the the appeal as it pertains to 41 Birch Hill Road. I'll entertain a motion to waive reading the
I
notice.
move we waive the reading of the notice.
Second.
We have a motion, we have a second, all in favor? Aye. As we're missing a full member tonight, Lenny, as an associate member, I'll appoint you as a voting member for this particular matter. Mr. Burke, here. Oh, you're welcome to sit wherever you'd like. Before we get started, just as a reminder, Mr. Burke will have you take the floor and provide your presentation. We've certainly received your written materials. And for the folks who are outside, come on in. We got plenty of chairs. We have no catering. Certainly provide a presentation. We've received all the written materials that that you've provided. Well, I certainly want to give you the floor. I do encourage you to, if you can, not go over too much of what's already been put to the papers. I encourage all the members, of course, to ask any questions. I'd like for this to be more of a dialogue as opposed to just a presentation and us listening. Please, to the members of the public, as well as to Mr. Burke, Any questions or comments made by members of the board are, should not be taken as reaching any decision by either that individual member or the board as a whole. That decision won't actually be made until there's an actual vote after the hearing is closed and we've received all of the information. At a certain point, I will stop and ask for any comments or questions from members of the public. I'll start with folks in the room. We'll then move on to folks on Zoom because we have a little bit of a full house tonight, both in person and virtually. I would encourage everyone to try to keep any questions or comments you have to be direct and concise. Please note that members of the board don't have to necessarily respond to any questions or comments. And certainly if there's a question or comment that goes to you, Mr. Birch, you're welcome to respond if you'd like. If you'd rather not, that's certainly your choice as well. And I'll repeat this later on, but to anyone who does have a question or comment, please first state your name as well as your address. I don't know how things will necessarily go tonight, but at some point, either tonight or if we have to continue the hearing for a future date, we will gather whatever evidence we need. At one point, we'll take a vote to close the hearing, at which point there'll be no further information that can be provided either by the applicant or members of the public. The board will then discuss the appeal, at which time we will take a vote. And 4 votes is necessary in order to overturn the decision of the zoning enforcement officer. With that, you have the floor.
Brian Burke, 125 Birch Hill Road, Stow, appeal applicant. Mr. Chair, the ZBA board members and voting associate member, and Mr. Slagle. As you know, I'm appearing tonight on behalf of myself and the members of my family living with me, including my wife, Maria Del Rosario, who is here tonight, to appeal the building commissioner's, in our view, inadequate enforcement of the Stow zoning bylaws with respect to 41 Birch Hill's use as a sober home business in a residentially zoned district. Pursuant to the ZBA rules, we are also appealing against the identical decision of the building commissioner rendered on our neighbors and abutters' request for enforcement. I see that many of these abutters are here tonight, and they may also offer evidence as to their objections to 41 Birch Hill's non-conforming use and why they are similarly aggrieved by the inadequacy of these enforcement decisions. First, for the members, but more particularly for our other community members, who are here in person or virtually, I would like to summarize the specific Stow land use ordinances which 41 Birch Hill's use as a for-profit business violates, as more fully set out in my 2 requests for zoning enforcement dated November 24th and December 10th of last year. In those 2 zoning enforcement requests, we asked for an investigation regarding the operational particulars of 41 Birch Hill's use as a sober home, because the new owners had not applied for a special permit and or site plan approval in which they would have been compelled to supply that information. Our request for that investigation wasn't acted upon, but from what we do know at this point, from the discussions members of our neighborhood have engaged in with the operators or the representatives of the owners of this sober home business, and what I've been able to winkle out of the internet in the course of my own researches, is that 41 Birch Hill Road was purchased in the spring of last year for close to $1 million, which seems to be above market price for homes in this neighborhood by 3 out-of-state residents. One of these out-of-state residents has extensive business holdings in the alcohol and drug addiction treatment and sober living house business in various parts of the country. As you've seen, across the country, drug addiction treatment and housing businesses generate more than $1 billion annually. And these revenues are generated almost exclusively from federal and state government aid programs and private health insurance. I have cited online marketing materials touting the immense profitability of opening a sober home business. And late last year, after all the zoning enforcement requests before the ZBA had been submitted and decided, title to 41 Birch Hill was transferred to 41 Birch Hill Road LLC. That is a for-profit corporation incorporated in the state of Delaware. From what the operators or owner representatives of this sober home business disclosed to members of our neighborhood, this commercial business was originally set up to house up to 10 occupants. All but the on-site manager would occupy these premises on a highly temporary basis, approximately 30 days each. As you know, however, residential districts in our town are intended for single-family dwellings. Moreover, non-commercial uses of more than 5 non-transient occupants are restricted from these districts, ZBA Rule 3.2. Non-commercial use is not specifically defined in the Stow zoning bylaws, but by referencing other provisions in these ordinances, this term clearly excludes business use of a scale of the for-profit sober home that is being installed at 41 Birch Hill. And while transient is also undefined in the Stow zoning bylaws, the Massachusetts Supreme Judicial Court in the Styler case, cited in my zoning enforcement materials, holds that non-permanent temporary occupancies, such as short-term rentals, are properly excluded from residentially zoned districts unless specifically authorized by another zoning bylaw. And Stow's zoning bylaws, as you know, contain a provision that prohibits all uses not specifically allowed in the text of the enumerated uses. The building commissioner's decision on the zoning enforcement request recognized and enforced the 5-person occupancy limit for single-family dwellings. Nevertheless, the building commissioner determined that this sober home constituted a boarding or rooming house specifically listed as allowable in Stow residential districts under 3.23. But as you know from my materials, rooming or boarding house as defined in the Stow zoning bylaws are tourist houses or where rooms are let and where meals may be regularly served by pre-arrangement for compensation, not open to transient guests, in contrast to hotels, restaurants, and tourist homes and lodging homes that are open to transients. The board, in the course of deciding this appeal, must determine whether this classification was correct pursuant to this definition, or whether another use classification is more applicable by the terms of its definition. We believe we identified the only 2 classifications that a sober home business at 41 Birch Hill could meet according to those definitions. Our position on this appeal, however, is that the classification of this use as a boarding house is legally untenable. While revenue-generating boarding houses or lodging houses are allowed in residential districts in the town of Stow, such uses are restricted to owner-occupied facilities with no more than 2 guests at any one time. The owner of 41 Birch Hill is a for-profit LLC Delaware corporation, not an individual, and its principal beneficial shareholder is domiciled in the state of Florida, which is one of the states where he operates those facilities I mentioned earlier. What is more, the sober home business at 41 Birch Hill is being operated in conjunction, from what we can see, as to an addiction treatment facility named Engage Wellness based in Acton, Massachusetts. Our understanding is that the occupants of 41 Birch Hill are individuals undergoing substance abuse treatment at that treatment facility, who are transported by vans each day to and from that Acton center to occupy this Stow single-family dwelling for periods of up to 30 days at a time. The board should deem occupancy for these periods to be transient and inconsistent with the definition of a boarding house. Consequently, 41 Birch Hill's for-profit use is not only transient, but commercial, therefore not allowed in Stow residential districts, especially insofar as being operated as an adjunct to another commercial enterprise for which we believe, for the purposes of Stowe zoning bylaws, should be deemed indistinguishable from 41 Birch Hill's use as a business. In our submission, moreover, the sober home installed at 41 Birch Hill more correctly meets the zoning bylaws definition of hotel, inn, motel, tourist home, or lodging house, as I've tried to distinguish in our original zoning enforcement request of November 24th. Because in those facilities, transient occupants are permissible. And it can be up to 3 or more persons, whether or not provisions for cooking, yada, yada, yada. There is no indication that the sober home at 41 Birch Hill is being leased to the occupants as opposed to staying at the single-family dwelling each night under a temporary license. Otherwise, those occupants would be afforded the protection of lessors under Massachusetts laws, including summary process. Of course, a hotel, inn, or lodging house is only permitted by right in a Stowe district zone for business or commercial uses. Clearly, therefore, either as a lodging house or as a hotel, boarding house, 41 Birch Hill's business use is non-conforming in the residential district in which it has been set up, regardless of which classification this board determines should be applied. Now, it would seem from the building commissioner's decision that because boarding houses are listed in the table of uses in the Stowe zoning bylaws as permitted by right in a residential district, the limitation on the number of occupants to 2 and the accompanying requirement that this property be occupied as a private, that is a non-commercial owner, and the rest of the text of 3.1.33 somehow can be ignored. However, this is not what the case law decided under Chapter 40A holds, and his determination violates that part of the Stowe zoning bylaws, which restricts uses in a zoning district according to the text of the enumerated permitted uses, irrespective of the use table. It is likewise obvious that when Stowe residents at town meeting approved boarding house uses in a residential district, they envisioned a small mom or pop operation on site, hosting 1 or 2 guests on a long-term or at least open-ended basis, more in line with the type of boarding house depicted in Carson McCullers' The Heart is a Lonely Hunter, if that's familiar.
I saw the movie.
Well, it's more like the boarding house that Lauren Bacall set up in The Shootist, in which John Wayne stayed. Maybe that one goes over people's heads. In approving small-scale boarding house uses in residential district, our town's residents plainly was not contemplating stays by more than 2 guests, which are limited in time to the length of their eligibility for temporary housing assistance or health insurance coverage. Nor were the voting Stowe residents at town meeting envisioning anyone operating a boarding house in a residential district that, according to what we know, provides the person who claimed that he would be managing this sober home business would generate $3,200 each month. That is $800 for each of the occupants, paid not by the guests, and for the benefit of an absentee out-of-state corporation, which also obtains additional financial benefits from operating this business in conjunction with their treatment facility in next door Acton. The building commissioner's boarding house classification is simply legally untenable, given the restrictions against non-commercial uses in a Stowe residentially zoned district. I've also reviewed the land use planner's memorandum, Mr. Slagle, submitted in connection with our appeal application. This memo appears to apply an interpretive gloss to the building commissioner's decision, such that owners of single-family dwellings may permissibly rent portions of their house to up to 5 unrelated occupants. But respectfully, this again misconstrues and disregards prohibitions on commercial uses and transient occupancy within a Stowe residential district. First, even assuming that the ZBOA upholds the building commissioner's classification of 41 Birch Hills sober house business use, then this use must be subject to the restrictions contained in the text of 3.2.1.3. And a sober home business, in our view, is more appropriately classified as a hotel or inn or lodging house. Those are the only two possible zoning classifications which could pertain to 41 Birch Hills business use as a sober home, and the courts have held, and they will hold, that a municipality's express use classifications necessarily excludes any other uses inconsistent with that defined classification. Where a town classifies uses according to the definitions in the text of the bylaws, it would be respectfully legal error to ignore those classifications. But even if the board decides to reverse the building commissioner's classification decision and treat 41 Birch Hill as a single-family dwelling in which the rooms are being rented out, which it should not, because there's a far more applicable classification for this use as a hotel, inn, or lodging house, the sober home operated at that address remains non-conforming. Occasionally, the owner of a home in a residential district may be compelled to rent out their entire home on a long-term basis pursuant to a written instrument to another family, while either the lessor or the lessee is, let's say, in between mortgages. In fact, that's the circumstances in which our family acquired 125 Birch Hill. The previous owner was leasing to a family on a long-term basis, and they were trying to obtain financing to purchase the property. Eventually, that financing was not secured, and the previous owner had a mortgage on their home, and they couldn't be expected to lease to the interested family without charging rent to offset their mortgage payments. But that is a wholly separate and distinct situation from one in which a homeowner in a Stowe residential district is trying to turn their property into a hotel or an inn or lodging house or even a boarding house, accommodating short-term occupancies, and especially where there is no written lease agreement. Any Stowe owner who attempted to license some parts of their home to 5 transient occupants would be operating a commercial enterprise for the purposes of generating revenues and presumably treating that enterprise as a business for tax purposes. The Styler line of cases cited in our original request for zoning enforcement hold that neighbors in a residential district are entitled to live in neighborhoods consistent with its residential character. That means that the other homes in that neighborhood cannot be used for business purposes, and the occupants residing in those dwellings must do so with a strong degree of permanency. Conversely, a constantly rotating number of even 5 occupants, all on a short-term basis, is inconsistent with the residential district's intended character. For this board to decide otherwise would be functionally equivalent to approving the establishment of hotels or apartment buildings in Stowe residential districts of up to 5 people. Therefore, it would be legally untenable to refuse to enforce the zoning bylaws provision on short-term occupancies for a business purpose in a residential district, even as to single-family dwellings. Moreover, as that planning board memorandum recognizes, the business use of 41 Birch Hill as a sober home occupied by recovering substance and alcohol abusers is not exempted from compliance with Stowe zoning bylaws, so long as these municipal land use ordinances are applied uniformly and equally. In our November 21st zoning enforcement request, we cite and discuss the Mac Realty case, which was decided by the Supreme Judicial Court last year, about the same time as 41 Birch Hill was acquired from the previous family owners. In that decision, the SJC held that the language in the 4th paragraph of Section 3 of Chapter 40 merely and only prevents municipal zoning authorities from adopting or enforcing zoning bylaws inconsistently as to congregate living arrangements, that is, in a discriminatory manner. But the Mack Realty case emphasized, in accordance with its holding in Styler and similar cases, the preservation of the residential character of neighborhoods is a legitimate municipal purpose which must and can be achieved by local zoning control. Indeed, federal and state courts, including the regulation I cited in my zoning enforcement request of November 24th, have long recognized that municipalities may regulate land use in order to protect communities' residential character and to make neighborhoods a sanctuary for people. The lack of stability and permanence of the sober home occupants in 41 Birch Hill necessarily subverts those goals, according to Styler. Therefore, short-term occupancies of a single-family dwelling in which the owner is operating a business, even a sober home, is subject to the same zoning restrictions that apply to all properties located within that residential district, because those restrictions are intended for the common benefit of all. In this appeal, I want to be clear, we are not asking the ZBA to treat a sober home any differently than it would any other single-family dwelling. Rather, we are earnestly requesting that 41 Birch Hill's use be determined non-conforming, as it would if any of the other neighboring properties similarly operated a business with 5 or more transient occupants, especially in conjunction with a commercial entity located in another town. The Stow zoning bylaws would not allow any homeowner in a residential district to turn their home into a hotel or apartment building or even a boarding house, hosting more than 2 occupants at any time. Uniformly applying these identical restrictions to a congregate living arrangement or a sober home is therefore non-discriminatory. Indeed, the Mack Realty case authorizes the ZBA's proper and non-discriminatory restrictions on uses according to the classifications contained in that municipality's zoning bylaws. Moreover, even if 41 Birch Hill's use as a sober home is eventually found by the ZBA to be appropriately classified as a boarding house and a by right use under the Stow zoning bylaw definitions, which we submitted should not, even the table of uses notified the owners of the requirement to comply with off-street parking regulations. That's 7.3.3.3. And according to that regulation, a boarding house must furnish parking spaces or 2 parking spaces at a minimum plus 1 space per rentable room or suite. It's readily apparent, and you from the photograph and just the appraiser's record, that 41 Birch Hill's driveway cannot accommodate 6 motor vehicles, and regulating off-street parking is especially safety critical in a cul-de-sac without sidewalks. But moreover, where a sober home business use is not permitted by right in a residential district, according to the provisions of section 3.1, including an adequate number of off-site parking space, the owners were required to apply for a special permit from this board pursuant to 3.2.3.5. And interpreting the allowed by right uses in a residential district, it would be anomalous for special permits to be necessary for boarding houses and hotels and inns and lodging houses in business districts, but not residential districts, other than those limited uses as defined, which limit the maximum number of occupants to 2 at a time, and where the property is occupied by the owner. The owners and operators of the sober home at 41 Birch Hill also never applied for site plan approval from the planning board for their changed use of the single-family dwelling pursuant to Stow zoning bylaws 9.3.3.4 and 9.3.3.5. According to the results of our public records request, these businessmen, who are very experienced in operating drug and alcohol treatment facilities in Massachusetts and elsewhere, never notified the town of this changed use. No written or memorialized inquiry to the building commissioner or the planning board into the possibly applicable zoning bylaws or the requisite permits or approvals was ever received. It is inconceivable that these businessmen did not know either of the zoning requirements and permitting approval pre-requirements before opening a sober home, or that they did not know that they were obligated to ascertain these pre-requirements before opening their sober home business. They simply chose not to give the town any inkling of their planned non-conforming use for the same reasons that they only disclosed their intentions to the Birch Hill neighborhood after they were found by some neighbors unloading an extraordinarily high number of beds into this property from a delivery truck. And the building commissioner has already notified the owners and or their representatives that they have additionally failed to comply with the state building code in operating a boarding house without compulsory state licensing. It is inferable from these facts that the owners and operators of the sober home at 41 Birch Hill felt it strategically advantageous to ask for forgiveness for establishing a sober home in the single family dwelling than it was to request permission to do so from the town of Stow as the bylaws obligated them to do. In that way, presumably, they thought Stow's zoning bylaws would be far more difficult to enforce against an ongoing non-conforming business use, especially one of the sober home. Therefore, we are also asking this board to issue an immediate cease and desist order for not only this plainly non-conforming use, which is unpermitted and unapproved in violation of the Stow zoning bylaws. While a ZBA decision may be rendered within the next 100 days, willfully and heedlessly violating the appertaining permitting and or approval requirements in the Stow zoning bylaws should not be countenanced for even one more day. A decision that 41 Birch Hill was not properly permitted or approved is self-evident and does not require 100 days to determine. The owners and operators of the 41 Birch Hill sober home will simply use any additional time to improperly generate further business revenues and hold off discontinuing this non-conforming use as a pretext for their under-the-radar zoning tactics in willful disregard of our town bylaws. We note that nothing in the ZBA rules constrains the boards from ruling forthwith that the owners and operators of the 41 Birch Hill sober home have flaunted and ignored the procedural requirements for obtaining approval for this changed use, as the building commissioner should have. And the board members can deliberate over the next 100 days over the precise substantive zoning bylaws that were violated by the non-conforming nature of this changed use. Now that I have demonstrated that 41 Birch Hill's business use as a sober home for up to 5 transient occupants is non-conforming with any and all by right uses in a Stow residential district, it remains for me to explain how these Stow zoning bylaw violations will aggrieve our family and all the other abutters, some of whom you may hear from tonight. According to section 1.2 of our town's bylaws, in pertinent part, they are purposed to regulate the use of land, buildings, and structures in order to protect health, safety, and general welfare of present and future inhabitants, to encourage the most appropriate use of land through a proper balance of residential, commercial, and industrial designations, and to induce its citizens to remain in the community. A sober home, by its very nature, poses unacceptable risks and hazards for which the Stow zoning bylaws were promulgated and then adopted at town meeting to prevent. As a sober home, as defined in Massachusetts law, houses occupants recovering from drug or alcohol dependency, some or many of whom may have criminal records. We do not contend, and I'm sure that none of my neighbors who give evidence in the course of these proceedings will contend that any family living on Birch Hill Road or anywhere else in Stow who had a member living with them who was recovering from alcohol or drug dependency, or even had a criminal record, would in and of itself constitute a violation of the Stow zoning bylaws. That would be discriminatory. Almost every resident in the town of Stow has had experiences with family members, whether living with us or not, who have struggled to recover from alcohol or substance abuse. Perhaps some of us even have family members with a criminal record, whether or not they live with us or not. And I'm sure that we've all tried to give those struggling family members the care and love that they need in order to recover. That is what families do. But even with the inadequate limitations imposed by the zoning enforcement decision, a sober home business at 41 Birch Hill will necessarily involve occupancy by not just a few, but perhaps as many recovering alcohol and drug addicts each year on a constantly rotating basis. And as I have shown in the materials that I have cited in our zoning enforcement requests, and the materials I have submitted in connection with our application, sober homes pose risks not just of a different degree, but a different order of magnitude than lawfully permitted residential uses.
Mr. Burke, I'm not trying to deter you from presenting your appeal, but as we've now gone for more than 20 minutes.
I only expect another 10.
Okay, if we can try to keep it to 5. We've got questions and I've got a full house and we'd like to get out of here tonight.
I understand, but as you must imagine, this is a very important.
I understand, but
And
but
we
does
did
that-
read your document.
we did read that one and the other, so.
But no matter, I'll do my best. Thank you, Mr. Chair. No matter how earnest any or all of the 50 or so transient sober home occupants at 41 Birch Hill are to strictly following their road to recovery, there will be regrettable lapses by a significant number. And as shown by those materials, these lapses may require emergency medical treatment by the Stow METs that will unavoidably jeopardize vehicular or pedestrian travelers along our cul-de-sac. Further, it is not engaging in speculation to be justifiably concerned that 41 Birch Hill's use as a sober home will not be restricted as, the occupants will not be restricted, as far as you know, from traveling off premises in their own vehicles. Sober homes do not maintain occupants in custody. And this may also cause serious traffic hazards. The sober home's business use may also result in noise and other offensive conducts, as also shown, for which these zoning ordinances were designed to prevent. Furthermore, my neighbors have been informed that some or many of the occupants of 41 Birch Hill will have criminal records. Again, because 41 Birch Hill's new owners have defied the applicable permitting or site approval requirements, we have no way of knowing how many of these 50 or so occupants each year will have criminal records or the type of the criminal offenses they have committed. It is decidedly not speculation to recognize that oftentimes criminal behaviors of more serious nature are precipitated or produced as a result of substance or alcohol abuse. There are many young children living along Birch Hill Road. I have a daughter on the autism spectrum who is especially guileless when dealing with adults. We cannot state that any of the 50 or so transient occupants of 41 Birch Hill will pose a special risk of harm to our children, but that's the whole point. We do not know and we cannot know. No, there is no practical way of compelling a sober home business to submit a list of its occupants to Stow authorities along with their criminal records. For that matter, there's no practical way of enforcing even a 4 or 5 person occupancy of 41 Birch Hill without constantly monitoring or the regular use of administrative warrants. And that is why we and all the abutters on 41 Birch Hill are especially aggrieved by this non-conforming business in a residential district. Most type of businesses subject to zoning ordinance enforcement are open to the public and to Stow municipal officials. Anyone can walk into a retail or convenience store and by and large determine from on-site observations whether or not the business is compliant with state or municipal laws. But we will never know if any of the 50 or so persons who occupy 41 Birch Hill each year poses a risk or hazard to our neighborhood until that risk is actually manifested. And furthermore, sober homes are not licensed or regulated in the Commonwealth of Massachusetts, as I've shown. And the only Massachusetts statute applicable provides for certifying sober homes through the freestanding independent Massachusetts Alliance of Sober Homes. And this certification process mainly requires that owners or operators take a training course, although it should be pointed out that certification would have required 41 Birch Hills owners or operators to ascertain whether their location within a residential district conformed with local zoning ordinances, including special permitting and approval requirements. Perhaps that's unsurprising. According to my check today of the MASH website, 41 Birch Hill is not listed as a certified certified sober home. Of course, sober homes may operate in Massachusetts without certification, but in the absence of this certification, there is no way for neighbors who come to have legitimate complaints about how 41 Birch Hill is being operated or any noisome or offensive conduct arising from its operation to even file a grievance. There's no one to complain to other than the Stow municipal officers. More to the point, we have shown by the materials submitted that the lack of sober home licensure has resulted in operational and safety problems in many other states. And these problems have prompted those states such as Iowa, Florida, and California to pass or consider passing licensure regulations and statutes. But until Massachusetts sees fit to do so, 41 Birch Hill sober home business will be operating without any state oversight. The principal source of oversight for such a business has got to be the Stow zoning bylaws. And as I've explained in our zoning enforcement requests, even the anodyne operation of a sober home will increase traffic and parking congestion, thereby hazarding public safety and welfare. Anyone who lives along Birch Hill Road or even the surrounding residentially zoned districts will be negatively impacted and aggrieved by violations of the Stow zoning law ordinances designed to protect Stow homeowners against these hazards. I have nothing I can offer about the owners or operators of this sober home. They didn't apply for special permit or site plan approval. We would know more if they had. But in the absence of this information, based upon the materials that we have cited and submitted, it is not unfounded speculation to observe that sober living homes in other parts of Massachusetts and this country have been improperly and illegally operated. And this seems to be especially the case with respect to sober living homes that are run as adjuncts or in conjunction to addiction treatment centers. And we ask this board to take special note of the materials we have submitted regarding the ineluctable proliferation of alcohol and drug treatment facilities and adjunctive sober living homes in communities. Especially, we're requesting the members to look at the Nova Law Review article that I cited, along with that New York Times article, which I believe has been presented and is before you. When a sober living home is installed in a community as an adjunct to a treatment facility, the establishment of other such facilities, such homes, routinely follow, because the economies of scale inherent in operating sober living homes in conjunction with treatment facilities, it is not difficult, it's rather easy to see how the introduction of even one sober home will cause other sober homes to follow. And it is also easy to see how the introduction of even one sober home will decrease property values for homes in the surrounding neighborhood. One of the purposes for which the Stow zoning bylaws require site plan approval is to protect property values in our town. The establishment of a sober home business at 41 Birch Hill will undoubtedly result in a decrease in neighborhood property values, which is not speculative and is plainly inferable, especially from the supporting materials. The resulting downward pressure on the value of our homes highlights a special irony in the agreement from the decision of the Stow Building Commissioner. Presumably, the occupants of the sober home is serviced by the vans we now see going in and out of that single-family dwelling and parking along the road in our cul-de-sac, and which shorts in limiting the number of temporary occupants at 41 Birch Hill to 4 recovering alcohol and drug addicts at any one time. This decision perversely incentivizes its new owners and operators to purchase another property in or around Birch Hill Road. The owners of the operators of Engaged Wellness or whatever treatment facilities are furnishing transient housing to the occupants of 41 Birch Hill will likely overpay for another property along our street or somewhere in the surrounding area. And they will just run the same vans with the other transient occupants of that other sober home in order to generate even more revenues. Should the decision of the Stow zoning enforcement officer be left to stand by this board, the supreme irony is that as sober homes likely proliferate in our town, all of our property values will correspondingly decrease unless we homeowners elect to sell our properties to another sober home. Finally, and I assure the board that I'm coming to a quick end, I want to emphasize that we're not attempting to deny properly operated, managed sober homes from our community. Rather, we are asking, as is our right, that any sober home business be located and established in conformance with the appertaining residential zoning requirements in order to preserve public safety, health, and welfare, as the zoning ordinances were required to do, and as the laws of this Commonwealth charge this board with doing. There are no other requests for this board to consider. The owners of 41 Birch Hill do not qualify under the Dover Amendment, nor have they requested any accommodation. It would be unfair and unjust to allow them to do so now. The ZBA must enforce these zoning bylaws, which protect our residential districts as they are written, and reject any use not in conformance with those ordinances. I observed that the Stow Building Commissioner's decision states that it was made in consultation with town's legal counsel. From over 40 years practicing in the same profession in this Commonwealth, I know full well that our town attorneys who have provided their legal counsel to the building commissioner and who will no doubt render legal counsel to this board in deciding our appeal have and will take into account all of the interests of Stow, including the potential litigation costs, time, and trouble that may result should this board, as it should, overturn the inadequate zoning enforcement decisions being appealed. That's part of what lawyers are paid to do for their clients. And as I've seen from the public records that were produced too late to include in the application, perhaps because I requested them too late, these are considerations that may be held by other town employees. Nevertheless, I know full well, from my experience as a member of this town's boards and committees, that the ZBA does not work for town council. The ZBA does not work for the town employees. Stow's legal counsel and municipal employees work for all of us in our community. And the ZBA is responsible to our community for serving its residents' legitimate zoning interests. Consequently, we are asking, if not insisting, that this board, render a decision solely in accordance with the plain language of the appertaining zoning ordinances and the evidence now before its members. And if this board does so, we are confident that the decision it renders will determine unequivocally that 41 Birch Hill's commercial use as a sober home for transient occupants does not conform with those uses allowed within Stow's residential district. And additionally, that determination will be upheld on any appeal to any court. Thank you all for for your patience in listening to our submission. Are there any questions?
I'm gonna take the prerogative as the chair to kick things off. First, a quick comment to the members of the public who are here. During the course of this, our members are going to ask Mr. Birch certain questions. There may be moments where you think, I know the answer to that, and want to raise your hand or shout out. Please do not. More so because you don't have the right to speak at that time. And this will then devolve into a very difficult meeting. During the public comment period, if you'd like to make a comment or answer a question about an issue that was raised, you're more than welcome to do so. I also just want to state for the record, besides the submissions that have been noted in the agenda for today's meeting, we did receive the additional documents. I believe you submitted the 6 articles, and there were 2 emails from Mr. Harnett and Mr. Stanton that we did receive, and all members of the board received as well. They just were not noted within the agenda.
May I ask Mr. Slagle for copies of those emails as a convenience?
I can send them to you, and they're also available on the town website.
Oh, they're already available. Thank you.
I can send them to you.
So I'm going to kick things off, and I'll open up to the board. During the course of the presentation and during the written materials, it is unclear to me about what is actually going on there today. So based on what you know, not what you believe, what you've been told will be happening in the future, as of today, what do you know is actually going on in the house? I.e., how many people live there, what's going on, or is it just all preparation for future use? And I understand, by the way, that I don't know if the applicant is here, but I understand that there's been a lack of communication. So I'm just going to state that as well.
From what I can state, from what I know personally, personal knowledge, the sober home is operating at 41 Birch Hill. There are vans going in and out. There have been, and I think I've submitted in the materials, police reports for people sleeping outside in a car on the road in the past month. Other than that, I only know what members of our neighborhood were informed by the manager or operator, Mr. Barena, when he was found unloading all those beds from the delivery truck. Mm-hmm. And I think I go into greater detail in our zoning enforcement request, but this is all we know and all we can know, given the lack of, as the chair says, of communication, as I would say, the lack of their required compliance with the Stow zoning bylaws, permitting and approval requirements.
Do we have any idea when or about this actually started?
That I'm not sure. I believe I was informed when I around the time I received the decision to our zoning enforcement requests that it had been that it was up and running. And that seems consistent with our observations. There may be people here tonight, and I understand the chair's injunction not to interrupt any of us at this point, but if anyone wants to bat cleanup for me, they're more than, in my opinion, in my view, more than welcome to do so. But I'm sorry.
And I'm not, by the way, I'm not expecting for you to say, yes, here are the 17 people and these are their names, all that kind of stuff. It's just, that's one thing that I've been struggling with, especially when you compare it to the Bach Realty case, where they knew exactly how many people lived there, what was going on, as opposed to here, where there's a little bit more of a level of uncertainty.
And all I would say to that, Mr. Chair, is that given that uncertainty, we should not allow this sober home business use to continue. It's up to them to come in before this board, or the planning board. And we, from what we know, our concerns are grounded, they're not speculative, and that is reason alone in our respectful submission for the ZBA to take action. I wish I could tell you more.
So do I. I'll open the floor. Please,
Yeah, I just have a question in terms of the issues. You mentioned, it's a for-profit operation and people are transient. Hypothetically, if this operation were a nonprofit and if the people that were residing there were residing on a more permanent basis, would you still have an objection to this kind of a facility? In other words, a halfway house for sober people of, dealing with alcohol and substance abuse.
With respect, Mr. Golder, it's very hard for me to answer such a hypothetical question, especially given the limited information we know. We know that 41 Birch Hill Road LLC is a business corporation. That hasn't changed. We know that from what neighbors have been told about the amounts of revenues they expect to generate each month, which is probably more than most people's mortgage on Birch Hill Road. We also, and again, I would have to know more of the facts. I've done my best to get up to speed on zoning law in the past 4 months. It's hard for me to answer a question as to another possible set of facts without knowing more of those facts and actually looking at the law. But I do know that from what we know, the Dover Amendment doesn't apply.
It's a dirty word. Dover Amendment.
Does that answer your question, Mr. Golder?
It does.
To the best I can.
Yeah, it's just that I'm trying to separate the issue of the for-profit and the transients from the issue of the home itself. If there's objection to the operation of a facility like that.
Again, it would depend on the circumstances, but from what we know now, and the evidence is before this board now, it's clearly a non-conforming use. I can't speculate or surmise as to other possible conforming uses. As again, I'm not as experienced with the zoning bylaws as the members of this board. I wish I could be of more assistance.
I just want to say, Lenny, there's other districts in the town which would permit it.
Yeah.
Okay?
Yeah.
It's not permitted in the residential district.
Would permit, what would it permit?
Permit a sober home,
So
hotel.
Okay.
But those are two different things.
But I mean, they could use a hotel as a sober home or a boarding house or whatever.
And
I went through I prepared something, if you can hand it out. So I went through the zoning bylaw and I took out all the paragraphs and definitions that applied to housing in Stow, including the use matrix. And I went through the first page there. I think it's the first page. I went through the commissioner's decision again. And I come with problems right away, and you can read it. I said, like in street, and Mr. Burke pointed these out. In a residential district use 3.2, the residential district is intended as a district for typical rural, single-family, residential, and non-commercial uses. This is a commercial use. There's no question about it. It should have been rejected just because of that. Number 3213, boarding houses or rooming houses for not more than 2 persons, provided that the house is also occupied by a private residence by the owner. This is not an owner-occupied residence. Therefore, it's not permitted as a boarding house. Definition: the rooming or boarding houses, a building or premises other than a hotel, inn or hotel, motor court, or lodging house where rooms are let and where meals may be regularly served by prearrangement for compensation. This is not, it does not permit, it's not open for transient guests. In contrast to a hotel, restaurant, or tourist home, which are open for transients. The guests are transients renting for 1 month, not intended to be maintained, not intending to maintain their room for a permanent residency in Stow. Stow Residential District is intended to provide dwellings for permanent household residency. The purpose use is not that of a household. Also, I didn't mention, I didn't wrote in by hand, parking. Parking is kind of limited on that site for 3 places, so they're not gonna get any more than that. On the next pages, I just went over what could possibly, how these things, each of the residential uses could be accommodated.
Ernie, I don't need to cut you off, but I also want to, I'm
Okay.
sensitive to also the time that everybody has
Okay.
here.
I'm
We
just
can certainly
saying,
bring these up for discussion, so
I
I'd like
think-
to try to focus if we have any questions.
I basically agree, on the zoning bylaws, I agree with Mr. Burke 100%.
Okay, well, at the same time,
Okay.
we still have a lot to
I'm out.
discuss, so I'd rather not render any judgments.
I'm out.
I've got,
Please.
transient occupancy. Do we have a accepted definition of that?
Of which one? Transient?
Mr. Burke, do you want to comment on that?
Yes, if I may. As I stated in my presentation, there is no definition of transient in the Stowe zoning bylaws. I've, in consultation with Mr. Slagle, I've tried to find some decisions or guidance by the ZBA or by the planning board in previous decisions about the use of that word. And so far we've come up short. Maybe we can do so in the future, but the point here is that when in the style line of cases, when they talk about transient, they contrast it with the degree of permanency. People who are there, if not forever, but for the long haul. They don't have, they have beliefs, and it's what their what the residential character of a neighborhood is all about. As I said, I'm sorry I'm not able to provide that. However, we would respectfully request the ZBA to interpret that term as it's used in the style line of cases where they prohibited short-term rentals. And that we would also ask that, as I believe case law requires or demands, that you give it the ordinary use. And given what we know, short-term, a 30-day or even 60 or 90 days we would submit, is a transient use. It's not a permanent use. It's the kind of thing that's more suitable for a hotel, inn, or lodging house, where people come in, they take take a room, they stay for however long they want, and then they're allowed. And as Mr. Dodd pointed out, those are perfectly permissible uses, subject to special permitting, I believe, in a business or commercial district. It's not in a residential district, either as a single-family dwelling or as a boarding house. Does that make sense? Have I answered your question?
It sounds like that's correct, that we don't have any.
There isn't. The closest is that there's a reference, in the definition of rooming or boarding house, in the definition, it ends by saying essentially not for transient use, such as hotels or hotels or restaurants or et cetera. So there's no defined, black number that says 30 days, but not 45 days or 60 days versus 90 days. So that being said, I think the courts have generally said that they will defer to sort of the local understanding of what transient is. I mean, one could understand that transient on the Cape is possibly different than transient in downtown Boston versus out in Stowe.
I'm sorry.
No, please go ahead.
I would only qualify the chair's reading is that the courts have said that the special deference owed to municipal authorities in charge of zoning is just that deference. It's not abdication.
Sure, understood.
And that the words will normally be interpreted in the context of their usual use. And also that they should be consistently interpreted. Although right now we don't know of any other interpretations or any interpretations of this word. But the point I would like, the overall point I would just like to make in this regard is, it's what do, people, it's not just the definition of transient, it's what do people expect when they hear boarding house? They don't expect 5 people constantly rotating in and out. They expect something more like, as I said, the 2 examples I gave, we all have from our common knowledge. When the voters at town meeting passed boarding house, especially in a residential district, they were thinking of a mom and pop operation. They had a couple of rooms that they let people stay in, like they let Ellen Arkin stay in, and The Heart is a Lonely Hunter. And there was, it was open-ended. It certainly wasn't constantly being rotated and limited by how much federal or state assistance.
At home.
And that's also,
So I just have an observation or a comment along definition lines. And I take exception that we don't have a definition for single family home. My opinion is it's inherent in the actual words that describe single family dwelling. It's not a.
yes, I agree, and I'm
Yeah.
sorry if I don't believe I said that, and I certainly didn't.
No, you did. I'm just offering my point of view on that particular, there was a comment about how we derived at this particular nomenclature to describe this. And I believe that we actually have a self-defined term called a single family
Yeah.
dwelling.
It's a household.
It's a household.
Except,
right.
except, would you agree that based on the definition of dwelling, it's 5 unrelated people? Now, notwithstanding the fact that I'm not expecting people to start banging on doors going, are you all related?
No,
That would be a very interesting process.
No.
But
no, I agree in this, and I think that's clear, household. But again, and I think I pointed this out in our zoning enforcement request of November 24th, household implies and connotes and should be construed as a degree of permanency.
Mhm.
It's not people coming in and out. Hey, this guy's here this month and this guy's here next month. It's people who are, maybe if it was appropriately zoned as a permitted use in the district, it could be it could be a dormitory or, off-site, off-campus housing or something. Those people are there for the term of their, for the 2 college semesters. Again, I don't want to go too long. But in that regard, yes, I agree with Mr. Moore about the single-family dwelling is defined, and it certainly doesn't include this kind of use in a residential district.
Do we know what the turnover is in these homes?
I think that's the open question.
Yes, not measurable.
There can be a generalization that is made about in sober homes, it's typically X, or if these folks operate something in Florida, what they might typically do. But I think that's part of the struggle there is the fact that, it is unclear as to what the situation is.
We only know what we've been told. And a 30 use would be about the time of a temporary rental voucher period, but more than that, I can't say.
So I was about to make a comment about a Sandra Bullock movie involving a halfway house, but we'll hold off on any further film references. If there's no objection from the board, I think because we've got a lot of people here, I want to open it up. So we're going to start. I'm going to take public comment. We're going to start with folks in the room, then we'll move on to Zoom. If you'd like to make a question, have a question for Mr. Burke, or make a comment to the board, you're welcome to. You certainly do not. I would also note that to the extent that we have a lot of people who are raising their hands, what I would ask is that we try to have everyone make one comment. If there's time, we'll go back around, but I'm not going to guarantee that we're going to do that.
Do we have an applicant on Zoom
Or respondent.
responding? You need to say something if you're there.
So,
Well, what I was gonna say is that Mr. Burke is the applicant, we have a property owner, but technically, they don't, this isn't like a special permit, scenario, so.
This is the applicant here.
Right, exactly.
Okay.
The other thing I would note is besides noting your name and your address, if you are in a butter, if you can just simply identify yourself as an abutter. If you're not in a butter, you can certainly still make comments. But I just wanted to do that. So with that, would anyone like to make, you can stay there or you can go back, whatever.
I'll go back.
Okay.
My wife, I'm sure, wants to chastise me.
Ryan.
So-
You did a good job.
So,
I appreciate it.
So, I'm assuming Mr. Burke doesn't need any questions or comments about that remark. Anyway, questions or comments? Yes, sir.
Hi, my name is Boyan Pavlov. I live on Birch Hill 33. I'm the direct abutter to the house. I'm so close to the house that I can see what they watch on their TV every single night. I can see how many people are walking in and out. I have 3 ring cameras. I can tell you exactly what time they moved, and I can tell you a lot. So they began operations end of October or end of November. It was around the 20th of November. And I can tell you why I know that, because that's the first time I had to meet our local police department. Why? Because someone was trying to walk my walkway entering the house. They were not informed what business they're entering, so they tried to enter my own house. At that moment, I became very agitated. This is my wife, Katie. We have 2 kids, 6 and 3. And she didn't know what's happening. We had an individual trying to walk. First of all, he was sleeping outside our driveway, walkway. Then he tried to walk inside the house, almost. I had to get on my ring camera to stop that individual. And then I messaged Mr. Behana, which I called before they even moved into the house, because for my old neighbor, Mr. Eric Selberg, I knew that the house was bought via FaceTime with the help of 3 investors, as we know. So it became apparent that it was going to be very difficult for me to get any sort of help from anyone, because there's a saying, the king is too far away and God is too far up. So there's no help, right? So I became aware that it's going to be an ongoing issue. So there's 3 more complaints lodged with the Hudson Police, with the Stow Police Department because of sleeping outside, and that became a problem. What we see is ongoing turnover. We see a lot of people coming and going, and this is a fact. I have a ring camera pointing to my driveway out, which records 3 months back, and I can provide footage. I can also see more than 5 people. I can see people being dropped at 10 a.m., 10 p.m., 11 p.m., midnight. There's multiple drop-offs for food deliveries throughout the day, non-stop. So we're not having a peaceful family meal. We're having this DoorDash constant coming and going, happening constantly. And I can see that. I can see it with my own eyes. I'm right there and I can see it. I see multiple cars, different personnel that apparently they probably work there, because I can see cars for 5 days, then the car switches to some other car. So we have a lot of employee turnover as well. So there's a lot of things happening, a lot of movement. Just what I'm seeing, a lot of illegal parking too. Constantly parking at the edge of my driveway. I had to call and make a complaint, because when they clean our street, the DPW have to do a U-turn after my driveway, and they don't clean my side of the driveway, because there's the van, there are multiple trucks, cars, everyone is parked right there. And no one cares about the ordinance of the town, a winter ban, snow emergency. It doesn't happen. I had to make those complaints that the attorney mentioned multiple times. So what happens if I have an emergency and I cannot exit my own driveway because the DPW cannot clean my street that I pay, like everyone else here, thousands of dollars. I just moved into my house a year and a half ago, maybe over a year ago. I've contributed my fair share to the tax pool of the town, and I expect to receive some of these services as well. So, as a father of 2 kids, I'm a little bit unaware of what type of individuals we have next door. I expressed this to Mr. Bahana, and he assured me that there will be no arsonists and no child sex offenders. So he offered some reassurance, but as a father, I don't think I can agree with that reassurance. I can see multiple people on my street walking. I see different faces. I bring my child to the bus stop outside the Correspondence residence every single day, and I can tell you that I see faces, different faces, and I can tell you that I've seen different cars, and there is one particular car, a dark Volvo, that has been giving me and my wife a very unpleasant stares every time they drive by. How do I feel living in my neighborhood when we have something like that? I Googled the 3 investors. They're living with luxury, $5 million homes, private yachts. They're flaunting wealth. Do they care about disabled people? I don't think so. I don't think that their passion is helping people. I think their passion is wealth building on the back of someone else. And I don't think that someone that purchases a property via Zoom or FaceTime has any interest in Stow as a town or the neighborhood at all. We have an employee of Engage Wellness that is trying to portray a face, but this is just a face to a very, very structured layer of protection now under an LLC that we are going to be very far removed from these investors if we ever need any real help. Because who am I supposed to call now if there's ever a need for me to address the situation? We have people constantly turning over. These people don't care about the house, about the neighborhood, about anything that's happening. They're just in and out. And I can tell it's more than 5 people. And I would like to ask the town and anyone how it is enforced, as well as these disabled people. Has anyone been inside the house to verify that these people are safe? Is the environment safe? Can they walk up those stairs safely? Can they navigate safely? Is the septic also okay to support all of those individuals? Why do we have 9 beds if we have only 5 people cap? Is the 5 people cap including the employee as well? Or is this 5 individuals an employee? Where do employees sleep? I see females in and out all the time. This is not a facility for men. I see women going in and out during weekends, long-term stays, over the weekend, all the time. Who's living there? I have no idea. Do their girlfriends come in? What's happening? Is this a brothel, guys? I don't know what's happening.
Thank you.
Thank you.
Any other public comments from folks in the room? Yes, sir.
John Mulroy, 80 Apple Blossom. I'm in support of my neighbors here who have on Birch Hill who have clearly been affected by this. And I urge the board to seriously consider the plain context here, that this is a non-conforming use under the existing zoning bylaws and to render the judgment accordingly.
Thanks, sir. Any other comments from folks in the room? I will come back around after the Zoom folks. Yes, sir.
Doug Reed at 56 Apple Blossom. And I just want to confirm that I too have seen cars from out of state, lots of different people going in and out of this residence. And I've been scratching my head for several months about this. So I just want to back up what these people are saying as their neighbors.
Thank you, sir.
That was Doug Reed.
That was Doug Reed.
Yes. Yeah. All right, I'm going to pause here. If we're going to turn to the folks on Zoom, if you have a question or a comment, if you can virtually raise your hand, I believe there's a button that they can press, and then you'll be taken off mute and being able to contribute. If you don't, that's okay too.
Tara Fernandez, stop. You can unmute yourself. I didn't turn that off.
Hello. Hi,
Hello, how
I'm
are you?
Tara Fernandez Davila. I'm at 48 Birch Hill Road. I live across the street from what is now operating as the sober home. And I would just like to confirm the amount of movement that I'm seeing, and definitely a lot of action out on the street with not only the van, but the other cars with Florida plates and other states. We've had to talk to them about, please don't park right in front of our mailbox. It's definitely been pretty difficult with the snow at this time, but overall, just definitely seeing a lot of movement and have concerns about this operation. I have two children. They are in college, but my daughter of 21 is concerned about the potential of safety in this neighborhood, and I think we all feel that this is a non-conforming use that does not fit a residential neighborhood.
Great, thank you very much. Does anyone else have any comments or questions, the folks being on Zoom? If so, please virtually raise your hand.
There's no one else.
Okay.
raising their hand.
All right, I will ask, only because you had mentioned it, I do think, is there anyone here who represents the owners of the property? Okay then. I'll give folks in the room, as you guys did come here in person, one more chance if anyone has any other public comments or questions. No? Yes, ma'am.
Hi, Kim Cedar, and JD Cedar, we're on Robert Road, so we're here to support, Birch Hill neighbors, because we're just down. And I think for me, it's been very uncomfortable to hear how underhanded everything went, and how under the radar. And I think as the gentleman, I'm sorry, I think it was Andrew, it's pretty clear, a single family home, and these neighborhoods are set up to be single family homes. And so I think this is going to be a really important thing for the zoning board to kind of lay down some laws.
Thank you very much. Yeah. Yes, ma'am.
Missy Reed, 56 Apple Blossom Lane. I just want to comment. So we don't live below this house, but we're catty corner from it. Start through the spring and the summer of last year, there's a lot of activity, both a number of houses up there, but on that house. And I guess the question is, the sale transpired in the spring, and they were the ones doing all the work before they opened their operations. Has there been any inspection of the building prior to the operation starting in November? And has there been confirmation about what is in the house from the standpoint of structurally that it offers for this quote unquote business use? Just a question.
I mean, we don't know. We don't have that information. All I can say is that to the extent that anyone would have needed to file an application for a variance or special permit, they haven't appeared before us, at least within the last 6 months. At least anyone from this particular address, unlike other folks. Mr. Birch, here's a question. What's the specific relief that you're looking for?
An immediate cease and desist order, as I said.
Do you think we have sufficient information to do that? As opposed, and I ask only because at one point during your presentation, you indicated, and I think it was in the papers as well, I thought I read that part of the relief was essentially asking for a zoning enforcement investigation. And I guess my question to you is that, are you looking for everything, or are we looking in stages? And I'm not saying that we're going to do one or the other. I just want to try to narrow that question.
Mr. Chair, the best way I can answer that is, yes, we did request further investigation. That wasn't there was some investigation by the building commissioner, and I understand the building commissioner's position. I'm not critical of him at all. I'm not chastising.
Of course.
And for the record, may I say that when my wife does chastise or criticize me, it's always warranted. Just so I can go back home tonight. Now to get back to your question. At this point, though, I don't think further investigation is necessary. We tried to go that route. But from what we do know, and it hasn't been gainsaid or contradicted tonight or at any point, this is a non-conforming use, and a cease and desist order should issue immediately, just for the procedural violations. But as I know, the board has 100 days, but I think it would be unfair or unjust to now allow the owners or operators of this property to come forth with a whole bunch of information. The way I see this playing out is, if the board is, we respectfully submitted, should enter a cease and desist order, either on the procedural violations and then later on the substantive violations, or just on, or just altogether. Then the very wealthy business owners who are behind this sober home will then take this to court, and then we'll have discovery, and maybe we can find out all these particulars at that point. That's the way I see this playing out. I don't know if that's an answer to your question, but lacking that, there's nothing else I can recommend to this board.
Other questions that the board might have for Mr. Burke?
This
Topics of discussion with him?
Well, just in general, this is procedural kind of a question. It appears as though there's evidence that's available. An individual, as in the butter, I think, is that something that should be captured and preserved in such a way that you may need it in the future?
Are you asking? I guess I'm trying to understand.
I'm just trying to decide, I guess there's some information here.
Well, no,
that
I
could be
understand.
relevant to whatever proceedings take place.
Understood. I mean,
It seems like,
beyond, I'm sorry, one sec. Certainly it's gonna be captured in the minutes that, that'll be.
Just save it.
So, you're talking about the video. That's for, we're not gonna revise one or the other. obviously.
I'm just, we heard that there is evidential information that indicates some of the activities that are going on that are perhaps pertinent to whatever decisions get made.
I think there's two things we have to address in the letter in our decision. One, that the building inspector's decision that he sent was not compliant with the Stow zoning bylaws, and list the reasons why. And also, there's evidence from the abutter that this operation is detrimental to the neighborhood in the way they're conducting their business.
Except I would submit that the second point that you raise is irrelevant. Now, people might say that's not fair, that's not right. Our job is to simply say, is it applicable under the zoning laws? There's plenty, the zoning bylaws. People have come before us for special permits or variances, and people might, there's a little bit of a difference because it has to do with the character of the neighborhood. Here, it's more, I would say it's down to the uses. I think there's plenty to talk about in that regard.
I wouldn't debate that, because there is a character of the neighborhood that's being deteriorated. There's also a safety factor that's out of control as well.
Yes, sorry.
I was just gonna say that we shouldn't discuss the board's decision.
Oh, sorry.
This is the point in the process.
Sorry, you're right,
where
you're
we're
right,
supposed to be taking in information.
Yeah, sorry, you're
So
right.
we should not be discussing the
Okay.
board's position.
Other questions or topics of discussion for Mr. Burke?
Well, more for us, should we reach out to the owners and manager of this operation and ask them to come in?
So they received notice of this hearing, of the appeal, and we do have a copy of a letter that was sent from it's in the record from the building department, which I think was sent in November.
Either
Early-
November or December.
Okay, late November, early December that was sent. Sorry, and they did receive notice of this hearing as well.
They did.
Yes, they did, yes. So, Rick?
I was just gonna say, the owner occupant part really jumps out. And just, where they've got in the deeds there, that it's essentially not being owner occupied. Just wondering if that, does that solidify that, or do we need something beyond that? Because in theory, if they were owner occupying it, changes it.
Well, let me ask Mr. Burke, would you consider that, would that change the analysis?
That would only be with respect to its proper classification as a boarding house. But first off, Mrs. McFarland, a corporation can't occupy anything. And it's.
Tell that to
even
Mitt Romney.
Pardon?
I made a joke saying, tell that to Mitt Romney. It's fine, it was a non sequitur.
Secondly, it's gotta be limited to 2 people. That's only if it's non-transient occupants. So yes, I think that the fact that it's not owner occupied, that's significant. But the fact that it's just as significant that it's being run as a business, and the only businesses or revenue generating facilities that are allowed in a residential district that are applicable would be that boarding house, but it's not, it's got more than 2 people, and the guests are transient. So those are 3 other reasons why that wouldn't apply. Again, we urge the court to consider the appropriate classification as a hotel, but I think it's a little bit beyond it. And to Mr. Chair's point earlier, I understand that the board is just concerned with the appropriate classification and the non-conforming use. The only reason that we talked a little bit about some of what's been going on there over the past couple of months is to establish our aggrieved status, which I know the board also has to consider. So in that context.
No, I understand.
Thank you, Mr. Chair.
Sorry, it's okay. I love being referred to as the court by that, so. So you refer to us as the court, as well as the board, yes.
I thought I said the board, but if I do, I apologize.
That's okay. That's okay. As also an attorney, I appreciate it. So are there any other questions or topic of discussion from Mr. Burke? And I will open it up for that first.
Thank you.
I'll give members of the public one more chance if anyone wants to raise their hand or say anything else. Any comments from staff at this point?
Well, I've provided materials to the board, as you're aware. Has been based on my discussions with town council. I would say for the board, if there is additional information that you need to keep the public hearing open. If not, I would recommend closing the public hearing, and then you would be able to talk to, in an open meeting, talk to staff or ask me to get a decision viewed by council or anything like that. So it's up to the board as to what your next step would be, which would be either continue or
right. Close. All right, so let me open it up to the board. Are there any other? Is there any additional information that we would like? I guess acknowledging the limitations I think that we have. One source is that are there any other members of the town, other departments or boards from which we think that we need information from?
Town council, maybe, further information, maybe.
Yeah, but I believe it might be, correct me if I'm wrong, your memo essentially encapsulates.
This is zoning. We don't, Board of Health hasn't commented, the police department, fire department, no one else has commented. It's predominantly,
Actually, go ahead.
oh, did I miss it?
No, it's in there.
The police, that was submitted by the applicant, and it was not in response to the email that I sent out to all other departments requesting comments if they had any. There were comments from the treasurer's office.
Right.
But that, I believe, and then there was the letter sent by the building commissioner to the applicant that he just sent us a copy of what he previously sent. Or not to the applicant, to the property owner. Other than that, there has been no other comments, as this is mostly just a zoning related issue.
Thank you.
Yes, sir.
Mr. Chair, I don't know if it's worth pointing out, but I believe the town administrator did do such a check. It was contained in a response to public records request, but again, it was not concerning zoning enforcement. And it was received by me too late. And again, I'm not blaming anyone for this, for me to include in the packet for tonight.
I'm sorry, I might be confused. What specifically you're referencing?
I believe the town administrator,
Oh, I understand.
and I don't have it in front of me and I can't recite it from memory, but again,
Yeah.
it was not directed, as far as I can recall, to, and I'm pretty sure it wasn't, concerning any kind of zoning enforcement or municipal zoning bylaws.
All right, so I guess the question to the board is, do you guys want to keep the hearing open, or are we comfortable closing it and moving on to discussion?
I'm comfortable closing it.
I'm reading a face, so I'm just asking.
I don't know. I always, discretion being the better part of valor, I always like to, see if there's any additional information to keep it open.
Yeah.
So I'd be inclined to keep it open and it didn't have to be, we could even meet next week as far as I'm concerned. I would like to, I don't know what's going on with these owners. I mean, I would like to, it's always, I'd like to hear what they have to say. I mean, just evading us. They have something that I don't like.
Yeah, no, I mean, I appreciate it. And I mean, I assume that to the extent that we continue this, they'll receive notice of any continuation. The reason, normally I would agree with you. My only hesitation, to be perfectly honest, is the fact that, this is an issue that, this is February 2nd. This is an issue that's dating back to, let's say, November, we'll say Thanksgiving time period or so.
Yeah.
And as far as I can tell, the only level of communication that's taken place with them has been what I'll call the building manager. I don't know what term, that he's had communications with a few of the neighbors. At this point, I'm not necessarily inclined to, give them a seventh bite of the apple, especially the fact that the building commissioner or the zoning enforcement officer, specifically actually reached out and contacted them. If they had said, no, we actually have 7 people, or even an acknowledgement to say, yes, of course, we agree with everything you said. And so I think, like I said, I think we've sort of crossed that bridge. So, but I get, I totally get the point. So, all right. Well, I'll entertain a motion.
I move that we close the hearing.
I second that.
All right, we have a motion, we have a second. Any further discussion about keeping the hearing open or other matters that we think we need, information we need to gather? No. Hearing none, all in favor? Okay, so with that, the hearing is now closed. We can no longer receive public comment or information or from the applicant or presumably the property owner. It's 10 of 9 right now. I am happy to start our discussion if people want to have it.
Okay, I'm fine.
I'll open the floor.
I don't have to go to work tomorrow.
I'm remote tomorrow, so
I think just in the bylaw, there are a number of points that weren't brought up by the building commissioner and the town council concerning it's a non-commercial use, and it is a commercial use, shouldn't be in the residential district. The fact that it's not owner occupied. And the fact that the parking, it just pointed out by a butter, is out of control. It's not appropriate for that neighborhood. We have zone districts that accommodate that use, but it's not in the residential district. It's meant there for residents, it's meant there for families, or whatever other arrangement they have, but it is a household arrangement. And we do make provisions for a mom and pop operation. It's restricted to 2 rooms. Parking has to be provided. And this doesn't meet that.
Oh, I'm all the way over the floor. Like,
Oh,
yeah.
okay, I thought you were
No,
talking
no,
to me.
no, no, anyway.
Well, I mean, I'll respond anyway. Yeah, I'm looking over the uses and this wouldn't qualify as a boarding house because it's not owner occupied and there's more than 2 residents. And I'm looking to see is there any niche here in which it would qualify in a residential neighborhood. Unless I'm missing something, I don't see it.
For me, that's a big piece there, because some of the other ones I can, see some, like even when the commercial, point, for people with disabilities, I'm not exactly sure where that's falling, if there's an argument there to be had, that there's some protection there. But it still wouldn't fall in because of this owner occupied.
Well, I think the issue on that is that because there's no definition of family in the bylaws, you have to fall back to, single housekeeping unit. Just try to interpret that. But which in the Bach Realty case in Fitchburg, I think theirs was 4 unmarried people. Here in Stow, it's 5. For me, that like one of the problems that I'm struggling with, as I've talked about now a few times, in terms of like the conversation I had with Mr. Birch, is really the fact that unlike the Bach Realty case, which if you read it is interesting, because there the zoning enforcement officer actually it was clear what was going on. I think they had like 13 people living there. It was a triple-decker house. They could really analyze what the situation was and then rendered their decision. And eventually it goes up because the owners of the property ended up appealing the decision of their board. And here, I don't love the fact that we don't have a sense of what is going on inside the house. But that's why I take credence in the fact of like the only facts that we do have is from the observations of the neighbors. And so, when you've got neighbors who are talking about at least the number of people who seem to be going in and out, that gives us at least what I would sort of perceive as sort of a more likely than not, understanding that even if you could, and there's a lot of ifs, get to the point where you just say, well, if it's 5 or under, then we're okay. Like, I don't even think we're there, putting aside like the transient pieces, the commercial pieces, putting aside, all everything else. Like, I don't even think we've even hit that particular baseline. And so I guess the reason I'm saying all of that is because, one thought to think about is, this word kind of goes towards what the relief is like how broad or how narrow do we think we need it to be, or do we want it to be? So I raised all these issues for discussion.
No matter what we do, it's going to be a long time to solve the problem. Because like he said, we'll be going to court. They're going to appeal whatever the decision is. And it just stretches things out. And the faster we can do it, the more precise we can be, the more, like cease and desist. What's that going to result in? Well, they're going to appeal that. Fine. The fining is so minuscule in this state, $300 per, offense on a daily basis, up to so many $1,000 any clip.
Right.
There's no, we don't have any real enforcement capability other than to go through the court system and get them evicted that way. It's gonna take time.
Well, I mean, ultimately,
Yeah.
we can only render to this, as I've
Yeah.
said in many other applications that have come before us.
But this-
We have a question before us, we have to answer it, and then it's up for others, for good or for bad, to do with it, you know, it's.
But I think our decisions have much emphasis that needs to be treated, taken care of as ASAP.
In that regard, we are like a court. We render
Yeah, we
a
are a
decision,
court.
but we
Yeah.
depend on other people to do the enforcing.
Yeah.
We don't have,
No,
we
that's,
don't have an enforcer from this board that's gonna go down there and shut it down. So,
so, if you'd like to volunteer.
well, I have to bring Yoda with.
So,
You're the chief judge.
so, yeah, right. So, any thoughts? Not the,
Yeah,
not the cold caller.
So all of these comments are all applicable. The thing that I'm, I guess, offended by is the fact that they just bypassed everything. They're not paying any attention. They've totally ignored any business practice process or any of the judicial process that we need to go through. And that's really offensive for them to just come in and say, we're gonna set up shop. Aside from all the safety factors and all the other maybe, anecdotal kinds of conversations that are around this that are imperative, it's real. The idea that the neighborhood is deteriorating for every minute that we don't take action is a concern.
Yeah, and my comment before wasn't, I wanna make sure it's clear. The comment I had before about that wasn't meant to be, to indicate lack of caring. I
Yeah,
mean,
no,
I appreciate the fact that, every one of these issues affects the neighbors, no matter where it is. I just wanna be careful about the fact that, again, notwithstanding the question of standing and grief, nature of the applicant and others, that the decision is not based on, do we think a sober house is a good idea or not, or do we
Yeah,
want
no,
like these
no,
people,
right,
quote unquote, in the neighborhood? Like, it's not a
It's not
NIMBY
about the
scenario.
occupancy,
Right.
this is about the activities that are going on in the neighborhood and how it's influencing people that are neighbors and living in that environment and trying to get through the day as a normal family.
I guess my question would be, do we have any say on that side of things? Because for instance, if it was a single family that was, uh, 5 people that, were engaging in activities that were upsetting the neighborhood to that effect.
No, that's
That'd
not
be
a
a
zone,
different
that's not a
problem.
zoning.
It's a zoning issue.
That's not a zoning issue, that's a noise issue, or we call the police,
Right.
or
So
whatever.
when
it
we
is.
start kind of talking on that level, I start kind of,
But no, the zoning
the
zoning
seems like-
laws ask for compatibility in the neighborhood. That's a zoning requirement that we have responsibility to pay attention to.
Well, that's
It's
not this question.
It's a zoning regulation that we as a zoning board have to make sure that there's compatibility of the zoning of whatever the case is that we're adjudicating.
I would agree to disagree with you.
Okay, that's okay. That's why we're having this conversation.
To Henry's point, if this were, say, 5 people, living in the house, even, not related, and let's say they had some kind of, substance abuse problem that they were dealing with, and they were just living there on their own, then I would say we have no issue or jurisdiction with it. But this is a commercial enterprise, and it's got transient people, and it doesn't seem to meet the corners of any use in terms of our zoning bylaw. At least none that I can see in terms of our table of uses, unless I'm missing something here. Let me know if I am.
I realize that we have a situation here, and so hypothetical doesn't really necessarily apply, but I'll play it out anyways.
Sure.
Take your scenario where you have 5 people, 5 unrelated people, 5 or less, whatever it is.
Yeah.
But they're renting the house. Like, fair to say it's a different situation.
Yeah. You go to the owner. The owner has to do something about it.
No, but from a zoning perspective.
They wouldn't be here. Wouldn't be in front of us.
Yeah.
it wouldn't be a problem.
These are zoning regulations.
No, I understand, yeah.
Yeah, I think that's what I'm kind of saying, when we go down the thing of, like, the there could be those effects on the neighborhood, but it seems like the zoning part.
Correct.
More where you're tough.
The behavior, whatever happened, we can't be responsible for, we're not responsible for that. Our job is to look at the zoning and adjudicate accordingly.
Mike, could you take the gentleman's statement about the butter and transcribe that into text for us? I'd like to just have a copy of all the problems he's seen and everything.
And then he's thinking it's more than 5.
So I do the minutes,
It's
so I
recorded.
will include it in the minutes, but I
Okay.
won't, the minutes are not supposed to be a transcript, it's supposed to be, I'll outline the points that were made.
Yeah, you can highlight what you have to say.
So,
And this is being recorded,
and
so
it is
it's,
being,
Okay. Just from a procedural standpoint, in terms of next steps, because we're not gonna complete this matter tonight, because there would still need to be, not just a vote on a decision, but actually to draft it up. Let me just ask, when's our next scheduled ZBA? March what?
March 2nd,
March 2nd. Do we have anything on the calendar for that?
no.
Okay, so there's two choices. One is we can hold this over till March 2nd. It's the only thing on the calendar, as of now. Well, then there's nothing else that's come in, so.
Yes, nothing has come in, but they have until the end of this.
That's right. So, all right, likely would be the only thing on the calendar. Or, like, if people want to do something sooner, say in 2 weeks, depending on people's schedules, I'm fine with either. We could do a special meeting for that. I'll just open it up to the group.
I would say time is of the essence here and that we should act as quickly as we can. 2 weeks would be fine for me.
Okay.
I mean, the applicant, I
Do
don't
you
know
have
if there's
any
any
scheduling?
implication.
2 weeks from now, the offices will
President's-
be closed.
Yeah, it's
since
President's
it's not
Day.
holiday.
2 weeks in a day. Sorry.
I believe I would not be available on the 17th because of the planning board. I believe.
Is that the Tuesday?
I can run without you.
I'm not getting into a fight.
The 18th, Wednesday?
I cannot do it.
That's an Ash Wednesday.
Oh, I take it back, the 17th is not a planning board meeting. I'm correct on that one.
It'd also be the 17th.
17th?
17 work?
Could you do the
Have a consensus on that?
17th? Can we meet earlier?
Yeah.
Yeah, sure.
Can you meet earlier?
Yes.
I mean, you're here anyways.
I won't go home, I'm 4 minutes away, so.
Later is better for me, but I can do
No, no, no.
earlier, it's better for others. I can do both. Later is preference, but
Okay.
How much earlier did you want to meet?
Oh, I was just gonna say 6 instead of
Yeah,
7.
sure.
Does that work?
About 3.
Mr. Burke, are you available on Tuesday, the 17th at 6?
Tuesday, the 17th at 6.
Yes.
I'll have to make myself available, Mr. Chairman.
Okay. I mean, technically you don't need to be here, but as a courtesy, I wanted to make sure you were.
Thank you very much for your kindness.
So, okay. With that, then, does anyone have any? I'm happy to continue the discussion, but if not, I'm also happy to take a motion and go ahead.
Yeah, I just think, in the interim time to be thinking in terms of, how we want to craft, once we make a decision, how we want to craft any kind of remedy for that decision.
Yeah, I think that's kind of what I want people to be thinking about. This kind of goes towards like specifically what the relief is. I mean, Michael, obviously, in typical, we'll be able to mock up the decision, but I think we're gonna have to put pen to paper that night and make sure we're pretty precise about exactly sort of what the decision is, what the basis is, knowing that it's obviously gonna be carefully reviewed at some point. So.
Yeah.
Anything else for discussion right now?
Quick question, what is your expectation for the next meeting? Would you like me to have a decision drafted? Would you like council to review it? Would you
Yes.
like,
All the above.
I'll have to put in that request for council.
Okay.
But I don't know if we'll be able to have council at all for,
Well, let us know.
yeah.
Or could you draft one regardless, having
I
town
could,
council's fingerprints on it?
yes, I
Yeah,
could,
let's do that.
but we can always ask for council to
Yeah.
review it before approving.
That's fine, thank you. It's not- Okay, all right, with that, I'll entertain a motion.
Make a motion that we adjourn the meeting at 21:05.
Want to continue? No,
No, you voted to close.
that's right, okay, sorry. Second. We have a motion, we have a second. Any discussion?
Any discussion?
Hearing none? All in favor? Aye. All right, and with that, we're adjourned for the evening. We'll see everybody in about 2 weeks. Thank you very much.